Divorce, bankruptcy. Divorce, bankruptcy. Divorce, bankruptcy. Which one do you do first? That's the question we're going to address today, so stay tuned, Bankruptcy Bailout Buddies. Welcome, borrowers and debtors, to Bankruptcy Bailout, because debt ruins lives, not bankruptcy. My name is Matt Burkus, Colorado bankruptcy and debt relief attorney, and today we're going to talk about bankruptcy and divorce, because the reality is that divorce and bankruptcy go hand in hand. Divorce is one of the leading causes of bankruptcy, and of course, one of the leading causes of divorce is financial problems. So first, let's define what the challenge is when it comes to divorce and debt. So just like the divorce decree has to divide your things, your assets, the divorce decree must also divide your debt. And this is a particular problem with marital debt or joint debt. So here's the problem. So let's say that wife and husband have a joint Chase credit card for $10,000 or with a $10,000 balance on it. Now the court is going to say, okay, husband, you got to pay the Chase credit card. However, that divorce decree does not change a person's liability to the bank. So both wife and husband are going to continue to be responsible to Chase for the payments. So what inevitably happens? Husband will eventually not pay because he can't afford to pay the Chase credit card, and then Chase is going to start contacting the spouse, the ex-spouse, the wife, about the balance, and then everyone's going to get all upset and pissed off, right? And invariably, I'm going to get the call saying, my husband's not paying the credit card that he agreed to, and Chase is coming after me. Well, yeah, because that's what they can do, because you're still liable to the bank, and your divorce decree doesn't change that issue. So what needs to happen, and I think, I don't fault divorce attorneys for not addressing this issue, because they mostly do not understand bankruptcy, but if many divorce attorneys, I think, don't do a good job of setting expectations about what happens to debt in a bankruptcy, or that the clients, the divorcing parties, don't fully grasp the situation. So that's the problem. You're going to have all this debt. So if you have marital debt, the question becomes, well, should you file bankruptcy before divorce or after the divorce? Now, if the two people can get along, if the two parties can get along, if husband and wife can get along and work things out amicably, then if the marital estate has more debt than assets, what I call a debt-laden estate, then it tends to be more beneficial to file a bankruptcy before the divorce so that each party can offload their debt. So all the debt or the bulk of the debt gets wiped out in the bankruptcy, and that sort of cleans the slate for the divorce. And that's just one less thing the divorce has to consider, and one less issue that can come up later on after the divorce is over. So if the marital estate is asset poor, as I call it, but has a lot of debt, then filing Chapter 7, assuming they would be eligible to do so in the first place, before the divorce is the best thing that can happen. And that's going to make the divorce easier. Now, if the marital estate is asset rich, if there's a lot of assets in addition to the debt, then typically you want the divorce to divide the assets and then file bankruptcy, because the risk is that with all these assets, with all these things, all this property, that those might be at risk in the bankruptcy. Now, of course, you need a bankruptcy attorney to review this situation with you and figure out what your options are. But as a general rule, if there's a lot of assets or a lot of value in assets, then it's better to divide those assets, because that'll protect them from the bankruptcy, and then each individual can then decide whether they'll file a bankruptcy after the divorce. So that's really how you address bankruptcy versus divorce. And the last point I would make relates to Chapter 13 bankruptcies. Chapter 13s are monthly payment plans for 60 months, and I would say practically under no circumstances should a divorcing couple enter into a Chapter 13, because that's a 60-month payment plan and you're going to be divorced. You're really creating a whole host of issues going forward. So if you can avoid it, you really don't want to be in Chapter 13 bankruptcy and divorced. It does happen. I got clients now where that's going on, but it's not ideal, and it raises all kinds of problems if something has to change later on. So, rule of thumb is this, to sum up. If you have a lot of debt and very few assets, you're going to want to file Chapter 7 bankruptcy before the divorce. If you have a lot of assets in addition to your debt, then you're going to want to divorce first, split the assets, and then each individual, the husband and the wife, can file bankruptcy on their own after the divorce. And then you should try to avoid filing Chapter 13 bankruptcy if you are considering divorce. So there you have it. Again, my name is Matt Burkus, Colorado Bankruptcy and Debt Relief Attorney. I hope you found this video useful. Best of luck to you.